The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, please be seated. We'll start off with United States v. Seward and Mr. Kendrick.
Good morning, Your Honors. May it please the court. There are three issues before the panel, and obviously I will follow the court's direction on what you want to discuss, but I'd like to start with the Confrontation Clause violation, because I think that is the clearest issue in this appeal, and it presents the simplest path for relief for Mr. Seward. That issue is governed by the Supreme Court's opinion last year in Smith v. Arizona, which held that when a substitute analyst witness testifies in court in reliance on the work of an absent analyst, and the work of that absent analyst is relevant to the case because of its truth or accuracy, then the Confrontation Clause is violated. I think that theory makes perfect sense because what it's trying to do is prohibit a witness who is once removed from the truth we're trying to get to from testifying in such a way that that truth or accuracy is insulated from cross-examination. And that was the heart of what Smith v. Arizona said.
Mr. Kendrick, can I ask you, just as a threshold factual question, what specific testimony by this analyst do you contend violated the Confrontation Clause? Like, because I think the problem is, I think some of it is almost certainly fine. So, like, what question and what answer is a violation of the Confrontation Clause?
So if I can answer your question in two parts. So
Okay.
I think you're right. There are a lot of her testimony is fine. When she testifies about how DNA works, how her lab works, those are all things that don't really implicate the Confrontation Clause at all.
And even if she learned them from reading, most of us learned most of the things we know from reading.
Absolutely. And I think that is what, the way I would look at it is general testimony. But when she begins to testify about the consistency of the DNA sample that's found at the crime scene and whether or not it's consistent with Mr. Seward's DNA, she is testifying to, and I'm going to call it a match. I think as DNA progresses, and I think as the legal system tries to progress with it, a match is not the right word. Really consistency.
But that's more of a improper opinion misleading the jury than a Confrontation Clause.
Right. So if I say that, what I mean is consistency. So what she is saying is that there was a match or consistency, if you will, between the sample and the defendant. But she is basing that on work that the absent analyst did. And if you look at the government's exhibit that the panel asked for, so it's not in the joint appendix, but the government, I obviously realize we need to supplement the record, but it's the slideshow that the U.S. Attorney put up when they were going through the precursor testimony. There's essentially 7 steps that go with DNA analysis. And I think that I wanted to try to avoid getting into the weeds about how DNA works, number one, because it might work against me to try to explain this. I'm not great at it, but.
Well, can I just tee up with you what strikes me as the difference? I'm not saying it's a controlling difference, but the difference between this case and Smith, and invite your response on that. So imagine that in Smith, I understand that the analyst testifies to basically 3 things. Here is how this normally works. I'll call that step 1, right? Step 2, here is what someone other than me, in this case, did in this case. Like the things that some other person did. I'll call that step 2. And then step 3 is my conclusion about what's true here, and that's step 3. Do you agree that that's Smith presents that, where someone testifies to 1, 2, and 3?
That is Smith.
Okay, so 1 is fine. We all agree that 1, totally fine.
Concede 1.
And what strikes me as tricky here, unless I'm misreading the record, the analyst here never expressly testified to 2. They just sort of testified to 1 and then testified to 3. I'm not saying that changes the answer, but first of all, do you agree that's factually true here?
I think, and I apologize. Tell me again when you said step 2.
Number 2 is where you describe what some other human being did.
Right. So I think she in some ways did, because when we started cross-examining her and asking her how assumptions were
Well, no,
made.
now you're introducing, I'm talking about her direct testimony, the analyst's
Exactly.
direct testimony.
Right. But I think she certainly testifies. Here's where I think things got confusing, and I think this is the glaring problem with this case, is that it's sort of framed on appeal, and the district court framed it as though she was had redone the work. In other words, but that isn't true, and that's exactly, she says quite the opposite. She
And
says
I'm willing to grant you that. I'm just willing to, but she jumps. So I guess another way to describe it is, and I'm going to use hearsay in a colloquial way. I don't mean hearsay under the federal rules of evidence. I mean an out-of-court statement offered to prove the truth of the matter asserted, not including the carve-outs that Rule 801 has. It seems to me here that she didn't repeat the hearsay like the analyst in Smith did, but her testimony is obviously reliant on the hearsay, because absent the hearsay, I don't know how she can say what she says at step 3. So that, in other words, that Smith is a case in part where the witness says the hearsay, whereas this is a place in which the witness doesn't say the hearsay, but the entire foundation and premise for their opinion has to be the hearsay, because otherwise I don't know how she draws any conclusions.
it has to be, and it's the functional equivalent. And I think it goes back to how we understand the working of DNA, is that there are a series of judgment calls, and that's not what it looks like on a crime show on TV. And in fact, when Summers from this court back in 2011 described DNA, and they talk about raw data generated by a machine, that is just simply not how DNA works. That's a
So
very
what's your
small-
best, I mean, it seems intuitive to me that you can't just avoid the Smith problem by just omitting step 2.
Right.
But I guess, what is your best authority for the proposition that you can't avoid the confrontation clause by just omitting step 2?
I mean, Your Honor, I have looked at just about all the cases that have come
Yeah, I
out
too.
after Smith.
I was really hoping you found something.
No, and I'll be honest with you, just last night I looked at every circuit's view of Smith, and there's not really anybody that's done it. So, we get to be first, which has some advantages, and I think that one thing that struck me when I was getting ready is a line from a 2016 U.S. Supreme Court case called Mathis that involved the armed career criminal, which gives us all trauma to hear. But they said a good rule of thumb for reading our decisions is that we mean what we say.
The dividing line in these cases is that you don't want the lab director to simply be a parrot. That you want to have the lab director have a degree of independence, and the lab director to have looked into the underlying data, to engage with the work product that the lab has produced, and to simply go on the stand as a mouthpiece or a conduit or a parrot is obviously presenting confrontation clause problems. But in this case, the witness seemed to know quite a lot about the particular DNA sample and report. And the testimony on the DNA on the DNA testing was actually quite detailed as to what the analysts had done. And we overturned this on this basis. We're going to be upsetting a good many convictions where supervisors didn't just parrot and act as a conduit, but took the extra step of engaging with the lab report. And when you look at the testimony here, it's not superficial testimony. She knew one heck of a lot about what transpired, and was able to talk about it in detail. And isn't that really what Smith and Summers are aimed at?
So I'm going to disagree with Your Honor, but I understand why it looks like she knew all of those details. And I want to be very clear that I do not think Summers is necessarily good law after Smith based...
Well, that's a gentle way. I don't know how you can possibly square Summers with Smith.
It can't be, Your Honor.
That was a friendly question.
Right. I was being overly polite. No, Summers is no longer good law. So Your Honor, what she did was essentially talked about what she was reading out of the report that the absent analyst had done. So there's no question she knew a lot about that report, and I was trying to...
Let me ask you a question,
Yes, ma'am.
because this is I think your argument is that there's this issue of discretion that the non-testifying analysts use in going about doing the analysis of the DNA. So
Yes.
give me an example of what would be discretionary, because I guess that whatever is discretionary is what you're arguing would need to, under the confrontation clause, is why you would have to have the non-testifying or the original analyst on the case.
Right, that's the critical part. That's what separates it from the raw data. And I wanted to go to it so I don't miscite this, but I think that if you look at JA 918 to 922, where she is, we are asking her, and again, this is cross, but the point is she didn't testify about how some of these judgment calls were made. So we're asking her about when you are looking at a DNA sample, there are peaks. And some of those peaks are flagged by computer software as a peak when they're
How long
actually...
did this jury trial, we got a jury verdict here. How long did this jury trial last?
The jury trial lasted 6 days, if I remember correctly.
6
Your Honor.
days. So on the basis of this, the government contends harmless error, but on the, you're asking us to overturn the results of a 6-day jury trial in which the jury convicted this individual of murder because he was angry that a certain package had not been delivered by a postal worker. Isn't this a case where the jury's verdict deserves a good deal of respect? Even independently, even assuming arguendo, and I don't know that I go with you on that, but I don't understand how that would justify overturning the results of a lengthy jury trial. I mean, that seems, the bottom line for me is that the district court deserves some respect under the abuse of discretion standard, and the jury verdict deserves some respect based on the totality of what it found. That's the problem. You've got, two little hills to climb, and if you manage to climb those two little hills, then you have to get down and grapple with Smith. And it seems tall order.
If you'll indulge me, because I'm out of time, Your Honor, this is the most important question, and if I could answer it, I think it's important. Yes, I am asking you to overturn the results of a 6-day jury trial and a jury verdict. But, Your Honor, I am almost always, and anyone who stands up here on appeal is asking to overturn the results of weighty and important proceedings in the district court. There are two ways that you view it. If it is an evidentiary issue, it is often going to be harmless error, and you may not do that. If it is a
all right. You've got some rebuttal
Yes, sir.
time, but I'm going to ask if my co-panelists have any further questions of you. I'll ask you to stay right there.
Yes,
Yeah, I'm not sure you got a chance to answer Judge Benjamin's question. Could you please do that?
Yes, so when the peaks that the computer software flagged, and I may get this backwards, but is either elevated stutter or artifacts, which is a byproduct of copying DNA. Essentially, the DNA samples are too small for the software to analyze, so they're copied repeatedly in order for the sample to be looked at under a system called Star Mix, or however there's various programs that do it. there's a series of judgment calls that the analyst makes to determine whether we throw out those peaks, whether we call them something else. Are they elevated stutter? Are they artifacts from the strand slippage?
But at the margins, isn't this a discretionary call? I mean, there could be clear cases where there was a confrontation clause violation. There could be, on the other hand, cases where there was no problem at all. At best, this is one of those, this is a marginal case, but it's not a clear-cut case for you, given the degree of engagement that the witness had with the report. And on those kinds of questions, at this point, doesn't it become judgmental for the trial court? Now, why don't you answer that on rebuttal, okay? Because you've taken,
Yes, sir.
you've reserved 7 minutes
Yes, sir.
for rebuttal, which is more than most. So,
Thank
okay.
you.
Good morning, Your Honors, and may it please the Court. I'm Nick Bianchi on behalf of the government. In the course of carrying out the murder of Irene Presley, Trevor Seward left behind overwhelming evidence of his guilt. The district court correctly admitted all of that evidence, and obviously on the confrontation clause issue that we've been discussing, I would submit to the court that she was not a conduit, a parrot for the missing analyst.
So your position is that the missing analyst did not have to use any discretion in the testing of the DNA as to how, and I can't get into the specifics of it, but what he was, I think, attempting to.
In terms of the judgment calls of stutter and all that. So,
Yeah.
no, I would submit, yes, the analyst did make those calls, the initial analyst, but I would say Dr. DeWin, also it's clear from the record and what she told the jury that she does, made the same calls herself. And I can point to parts in the joint appendix where she discusses what she does, because in Smith, they brought in an analyst that had nothing to do with the original testing, who just looked at her reports, and his name was Longioni. The original analyst was Rast and Smith. He took her notes on the stand, referred to them, related what was in them, and what we have here with Dr. Nguyen, who was the one who had to sign off on the initial results in this case. She testified, among other things, quote, "What I do is evaluate all of the work that has been conducted to ensure that the results that the analyst comes up with is consistent with the work that's performed and what the data says as well." She went on to testify, "I also review the controls and the original data itself to ensure that the calls the analyst is making are accurate." Again, she said, "I'm verifying all of the DNA profiles to ensure that I would reach the same conclusion." And while she didn't do it here, she explained, no, she did that here.
Okay.
I'm just finishing the sentence.
Okay. I was like, you're about to tell me something she didn't do.
No.
Okay.
What she didn't do in this case, but she testified that she will do if necessary, is when she's doing this review like she did here, if she disagrees with something, she'll kick it back and say, hey, take a closer look at this. Again, showing that she's doing her own.
Is she doing this as she supervising the analyst, or is she doing this as reviewing the notes?
She's the supervisor. So, again, she,
I
you know,
understand, but in her role as a supervisor, is she supervising the analyst doing the work?
No,
or if she just reviewing, what she's testifying to sounds like her reviewing the notes and saying, I would do it the same way.
no, I believe the analyst is making their calls, looking at what the machine puts out, making a call, and then we submit that the record shows that Dr. Nguyen, as the supervisor, is looking at everything fresh herself and then seeing what the calls are made. Because
Okay, so at some point, this is about how you read the analyst testimony, but for
Right.
purposes of this question, I want you to assume that I read the testimony this way, and then invite you to tell me, if I read the testimony this way, what are the implications,
Certainly.
rather than fight with me about whether this is what the testimony says.
Right.
So I read the testimony as saying that she could only compare the profile produced by the lab, that the only reason she could do any of the things that she herself did, and I agree, she said she did some things herself, but I read her as saying she could only do those things because she accepted as true the analyst had performed proper extraction and used appropriate methods to create the DNA profile in the first place. That there's no way that I read the supervisor saying, I can't even do the things I do unless I assume that the way they extracted it was correct and the way they created the other methods to create the profile were correct. If I read it that way, why isn't that a confrontation clause problem? Because she is relying on someone else's statements that they did certain things in a certain way.
I think if you read it that way, then I think you're right. There is a confrontation clause issue that then we look at further analysis.
Sure, yeah, I guess maybe not that's the answer, but that creates a confrontation clause issue.
Right. I think that gets us into the end around that Smith talked about.
Okay, and then can I move you to Summers? How in the world has Summers not been abrogated by Smith? It seems wildly inconsistent with Smith.
I don't necessarily disagree there. And so I think Smith is.
Because I read Summers as saying, as long as the person at the back end does some of their own work, they're allowed to relate statements from the earlier person, and that seems to me categorically inconsistent with Smith.
I think some of their own work is inadequate, but if it's a completely independent review.
Like they say, given the predominance of the independent, I'm reading from Summers, just to be clear. I'm reading that in Summers, the key analytical move this court made was to say, because the person later did independent subjective opinion and judgment, there's no confrontation clause problem. I don't see how that survives Smith.
No, I understand that, and I certainly appreciate that. And I think what I understand the appellant's argument to be in terms of, the DNA analysis and where it become, how much the testifying witness had to rely on the initial analyst to reach her conclusions. I think the point that Mr. Kendrick was making both at trial and today is he's focused on the judgment calls that have to be made in coming up with a
The
conclusion.
whole question of the degree of involvement of the supervisor, it's a matter of degree. To what degree was the supervisor involved in questioning the conclusions, in making independent judgments? To what degree did the supervisor familiarize herself with the details of the report? And isn't that question of degree under the Smith decision a discretionary question for a district court in supervising testimony?
Yes, I agree, because Smith doesn't say you always have to bring in the person that did the first analysis. And I'd point to, again, I've said some quotes earlier from Dr. Nguyen's testimony, but Joint Appendix 908, I'd also say where she says, quote, I also review all of the positive and negative controls conducted during the laboratory process, and I think this is key, and then I independently review the conclusions to ensure that I come up.
Isn't the Smith test of independence, doesn't it set this up as a matter of degree?
I believe so.
Okay, and if it is a matter of degree, that would be in the course of an evidentiary ruling where the district court is doing the trial. A matter of degree has to be a matter of discretion. And surely, you can say under the abuse of discretion standard, well, I might have ruled differently, but that's not the question. The question ultimately of wasn't there enough independent review of the report as to move this into a judgment call? And doesn't Smith indicate that and lay the groundwork for that?
Yes, Your Honor, and of course, with a confrontation clause issue, we're reviewing de novo, not for abuse of discretion, but I think even then, again, so it's a matter of, do you find, well, one, we've got Judge Coggin's ruling at JA 890, where he says that finds that she independently engaged in review or analytical process.
Go ahead.
But that's just Summers, and that's just the thing you said
Right,
was
and that-
abrogated by Smith.
Right, and that's.
I don't care that she did her independent review. The question is whether she impermissibly relied on some statements of something
Correct.
she didn't do.
That's correct. This was all pre-Smith. But And again, obviously, that's where we have a difference here on both sides as to whether she did enough. Our opinion is that it's clear when she talks about independently reviewing conclusions to ensure she would come up with the same results, that she reviews the controls and the original data itself to ensure that the calls the analyst's making are accurate.
You know, we're having, I understand your point, and it's a good one to make. This is a serious matter here. We're talking about a murder of a postal worker because of anger over not delivering a package in the way a postal service patron or customer wants it delivered. And but we're talking about a 6-day jury trial, and we're talking about a case of murder under the thinnest of pretexts. There's no reason for what happened to that postal worker here. Was killed for no reason. And we're talking about a jury verdict where 12 conscientious citizens rendered judgment after 6 days. Now, what impact did this one piece of testimony have upon the totality of the trial and the evidence? And I gather with this particular testimony, it was subject to cross-examination, was it not?
It was, absolutely.
And if there was some of these confrontation clause problems can be resolved through cross-examination, and they may the district court might say as a matter of discretion, this goes to the weight of the testimony and not to its admissibility. And if a defense counsel feels that the lawyer or that the supervisor is acting as a parrot, that you can expose the lack of depth in the supervisor's role through cross-examination itself. In other words, the confrontation clause opportunity helps to mitigate any problems on the confrontation business, because you can say, look, this report, you don't know anything about it, but that's not what happened here. She knew a lot about it. She knew a lot about it.
That's correct, Your Honor. And to be clear,
But in the totality of this trial, reading it through, it's just hard for me to think that the whole thing turned on this question. Given what she knew, given the opportunity for cross-examination, given the gravity of what was done and the evidence that was accumulated as to what was done, did this trial turn on this little point?
I don't believe so, Your Honor, and I think so. Obviously, the point of this testimony and the conclusion that was reached that was damning to the appellant is that his DNA was on the inside of the driver's door. Now, what's not contested here today,
The bloody handprint?
the bloody handprint, his hand imprint and palm print on the outside of her car, an individual that the appellant knew, seeing him driving at a high rate, driving Miss Presley's car from the murder scene to where she was left, and then we could go through everything else. But so I agree that with Your Honor, Judge Wilkinson, that I don't think it had such an impact that the case, that he otherwise would not have been convicted but for that testimony.
Can I ask you this? So you heard me ask your colleague about the step 1, step 2, step 3, and that in this case, I read the analyst is not testifying to step 2.
Right.
But I guess one way to think about this for me as an evidentiary matter which intersects with the Sixth Amendment is, so when the witness says, they say, what is your conclusion about what happened here, right? If defense counsel had said objection, lack of foundation, at the moment where the supervisor is asked, what is your conclusion? And then the witness, the counsel says lack of foundation based on her testimony so far, I have no idea what that conclusion would be based on, because she hasn't explained how she knows anything about the facts of this specific case. The answer would have been, I relied on statements that someone else made to me, right?
I don't think so.
How do you know that the test results you reviewed were actually the sample taken from the crime scene? Someone else told me. How do you know that this DNA profile was created correctly? Someone else told me, right? Or I read some statement in which someone else said that.
Well, and I think the original analyst, because again, their issue was with the judgment calls that were made with stutters and alleles. That's what they tried to focus on in cross-examination of Dr.
But that's
Nguyen.
not their job. I mean, they objected to this testimony, right?
Right.
They're not limited to the grounds on which they crossed the witness
No,
on after the testimony was allowed in.
That's correct, Your Honor. But I think, the DNA is coming
So,
from...
sorry, can I go back? What
Yes.
would the supervisor have testified if asked as a prelude to being allowed to give this opinion? How do you know these things about the specific facts of this case? What would she have testified to?
I believe that the answer that she would have given would have been the same one that Ms. Machichin would have
I'm
given
not-
if she had been there, in terms of, this is how we learn, because she did review the whole case file. She knows what...
How do you know that's the case file for this case?
Because she, again, I'd have to look back when she got into the specifics of this case, but she testified as to what she does as a supervisor.
I guess let me take a step back. Is the government's view that you can evade Smith by just omitting step 2?
No. We just don't believe that she omitted step 2.
Okay, but that's important, right? So it is not the position of the government that as long as the person never actually says every conclusion I'm about to give you is based on inadmissible hearsay, you can avoid the problem. I mean, look, under the rules of evidence, you probably can do that under Rule 702. But I don't think the Confrontation Clause lets you do that.
Yeah, no, this was, I agree with Your Honor, this was not an end around or trying to be cute or anything like that. We felt that she had a sufficient independent basis for all of her knowledge, and we think the record shows that. And I think, to be clear, the government's position is the only possible statements that may even get to a Confrontation Clause issue were the ones brought up earlier that were questions on cross, where she was asked specifically about judgment calls that someone else made. So she answered those questions directly about what someone else
Well, I mean, by asking those questions on cross, he probably waived any Confrontation Clause objection to what she was going to say in response to his cross-examination.
And that's what I would submit. So given that, we do not believe that her testimony creates any Confrontation Clause issues and is not, even with Smith coming post-guilty verdict, we don't believe Smith does anything to change the decision made by the district court in this specific case.
Let me ask you a
Case.
question and
Yes,
follow
ma'am.
up to Judge Wilkinson's question. So let's say, for whatever reason, we think that you have a Smith Confrontation Clause issue. And Judge Wilkinson asked you earlier about the abundance of other evidence. Do you think does it matter at all? I know the lower court made some comment regarding this case being strictly circumstantial evidence. Do you think that affects your argument on your harmless area argument?
No, because as Your Honor knows, circumstantial evidence is just as good as direct evidence, and the jury's instructed on that. And so, no, was there an eyewitness to the actual murder? No. But when you have everything else and the timeline that was presented to the jury in terms of his movements that day, what puts him in certain places, even though it's circumstantial,
Even excluding the DNA, you feel as if the government's evidence was still...
Yes, Your Honor.
Okay.
And I'm happy to tick through everything.
Well, can I go back? So now it's striking me that to the extent you and I are having a conversation, it's literally about what she testified to, so I asked someone and someone has provided me. This is page 908 of the JA. This is what I understand the analyst to have testified to. As a technical reviewer, I reviewed the chain of custody. I verified the notes against the chain of custody. I also reviewed the description of the evidence items and the item numbers that match up to the DNA results. That's the testimony of the supervisor. In other words, she's saying, I read some things that someone else wrote, and I used those as the basis in part for my conclusion. Is that not what she's saying there?
I think she is saying that she did all of that.
Why isn't that a confrontation clause problem? She's saying, I listened to what someone else said they did and what they found. I relied on that in forming the opinion that I'm about to give you.
Because I don't think that's what she relied, she's saying she did those things, but I don't think she's going as far as saying, I relied on that. I think a few sentences, or a sentence later, when she says, I also review all of the positive and negative controls conducted during the laboratory process.
How does that make it better, not worse? She's saying, I relied on some other things that the person who's not me also did.
Well, because I think laboratory controls we're talking about, I think then you're getting into what the machine's doing.
Okay, take your point. The machine is not a confrontation clause problem.
Right.
Fair enough.
And so, and then I independently review conclusions, meaning to ensure that I come up with the same conclusions as the analyst. I think there's no other way for her to do that than to do her own analysis, if you will, and then see does it match the initial analyst. So yes, of course she's going to review what the initial analyst did, but in terms of what she decides the ultimate conclusion is, it's based on her own independent work.
In these instances, it seems to me that you make an interesting point, and that is that invariably the supervisor, if they go on the stand, they're always going to agree with the individual whose report they are supportive of, and because otherwise they wouldn't go on the stand at all. So there's always going to be a degree of agreement. But the degree of agreement doesn't, that's not the test. That doesn't, the fact that there's an agreement doesn't mean that there's a confrontation clause violation. The question is, what is the basis for the agreement? And as to that point, the defendant rightly is afforded the full scope of cross-examination. And you can say, well, what basis do you have for doing that? Have you looked at the, have you actually looked at the report? Did you do this? Did you do that? You can vigorously cross-examine that report, and if the supervisor doesn't have persuasive answers, it's going to reflect very negatively in the jury's mind. And so what I'm saying here is that a confrontation clause violation, and this is, I wouldn't concede for a minute that this is a clear confrontation clause violation. I think it's a discretionary matter, and as to the admission of evidence as a discretionary matter, that is always subject to cross-examination itself. And the cross-examination can act as a mitigating factor for any marginal issue over the confrontation clause. Do you see what I'm saying?
Yes, Your Honor, and I know I'm over
Because
time.
there is confrontation here. There is confrontation. So it says a confrontation clause violation. Well, wait a minute. There's vigorous cross-examination, and it's hard to say, well, there's a real huge confrontation clause violation when she's subject to confrontation in the most direct sense.
Yes, Your Honor, I agree. And as I said earlier, Smith does not say you always have to have the original analyst come in and testify when you're getting into lab results of any sort. And again, I'm over time. I won't.
That's fine, but let me ask my friends if they, Judge Benjamin, do you have any questions? Toby?
One quick one. Just to be clear, it's not your position that it's okay that you can't cross-examine X because you were able to cross-examine Y, right? Like, it's okay that you can't cross-examine person X. There is no principle of confrontation clause that says, so long as the government is able to cross-examine Y, here the supervisor, it's not a problem that you couldn't cross-examine X.
That's correct.
Okay.
Yeah, and so, again, because we're over time, I think our brief lays out all the other evidence that would lead to a harmless error analysis. and we'd ask that the court affirm the
All I'm
appellant's
saying
conviction.
is that if if there was no opportunity to cross-examination, or if it was curtailed arbitrarily or whatever, that it would have compounded any problem.
That's correct, and they made the choice
That's
to.
all I'm saying. I'm not saying that invariably that the opportunity to cross-examination cures any particular cause. That's not your position. Judge Heitens is absolutely correct about that. But it's a factor.
Certainly,
It's a factor. I mean, it happened.
yeah.
It's
Yeah.
a mitigating factor.
Absolutely. They made the choice to cross-examine Dr. Nguyen about someone else's decisions, knowing that Dr. Nguyen was going to be the one there as opposed to that witness. So, again, we'd ask that this court affirm the appellant's conviction. Thank you.
All right, so you've got some rebuttal time.
Yes,
Mr.
Your Honor,
Kinder, can
and I
you
just-
start with harmless error?
Yeah, but I
What
just.
about the bloody handprint?
Right, I know. And listen, that candor to the court, that's the problem. I get it. I understand the evidence, and I understand that was pretty important and powerful evidence. But this is not an evidentiary ruling that I am arguing about. In Smith v. Arizona, 6 months ago, the United States Supreme Court told us this is a confrontation clause error to which there are not degrees. It is or it is not. It is from the exact same amendment that gives us that jury trial we're talking about. It is not subservient to anything in that amendment. It is important. And what happens when we look at this, we go to, and I don't think these are cited in the brief, but Chapman v. California and Fahey v. Connecticut are some 1960s Supreme Court cases talking about constitutional violations and harmless error. And this court has cited those opinions. I think the one I found most recently was in Corbello, which is 343 Federal 3rd at 278. But we ponder everything, and is there a reasonable probability that the evidence complained of might have contributed to the conviction? This is not abuse of discretion. We do not give the district court a pass for making a judgment call. We look at this violation, and this is a confrontation clause violation under Smith v. Arizona. It is, when we were talking about the line of questions that were asked in Smith v. Arizona, if you look under the U.S. Reporter at around page 797, they excerpt the trial from the Smith v. Arizona case, and they put the series of questions in there that they have a problem with. And then if you go to 907, 908, and 909 in RJA, they're slightly more detailed, but the exact same theory. It is all these things I have done that are just part of the checklist. And I struggle because science obviously is why I became a lawyer instead of a scientist, but I was trying to think of a good analogy, and I think about checking someone's math, and I think about maybe in the accounting world, if two numbers add up to the correct number, that is what she was technically reviewing. What she was not doing was creating those numbers. And that is why this is critical. That is why the Supreme Court, and I wasn't being flippant when I cited Mathis, but the Supreme Court said in that case, we mean these things when we say them. My concern if we start getting hung up in not properly evaluating the Confrontation Clause violation.
This is so far removed from the Fountainhead case, which was Crawford, where the Confrontation Clause was because there was the individual testifying really had no engagement or independent review of what they were testifying about. But the facts here and the evidence, the detail of the testimony and the evidence of independent review of the data just seems to me a long ways away from the Crawford case and what it was originally concerned about. We would have traveled a good distance to say that something like this was a Confrontation Clause violation.
Well, but Your Honor, we didn't go from Crawford to Smith. There were waypoints along that journey in Bullcoming and Melendez-Diaz where the Supreme Court is clearly evolving Crawford to apply to what we see more and more of in trial work, which is scientific evidence.
It
And
just feels to me like ever since Melendez-Diaz, the Supreme Court's like, Crawford is not applicable to experts. And over and over and over and over again, the government's like, we came up with a new argument for why Crawford isn't applicable to this expert. And over again, the Supreme Court says, no, Crawford is also applicable to this expert.
And they told us the answer to this case in Smith v. Arizona, and they addressed the vast majority of the concerns that we've discussed this morning when they said this is not an evidentiary issue. State and federal rules of evidence will in no way override the United States Constitution. So even when we get into like the degree of involvement in the judgment calls, what Smith v. Arizona said, if you didn't do the work, and the truth of that work matters.
The point is, you can't assume that somebody, just by virtue of holding a position as a supervisor, is thereby rendered ignorant of what it is that they are supervising. I mean, it seems to me you making a jump that just by virtue of being a supervisor, that presupposes ignorance, and it doesn't. The supervisor didn't perform the DNA test herself, but there are supervisors, and then there are supervisors. And some supervisors just sort of wave a wand over it and accept whatever the subordinate does. But there are other supervisors who are hands-on and who get into it. And I've run across both kinds, but there are some supervisors that are pretty challenging to deal with because they go into detail, they ask questions, they're vigorous in every way, and this seems to be one of those. It seems to be the involved kind of supervisor over the kind of supervisor that just says, oh yeah, it's fine, no problem. I grant you there are supervisors that just wave a wand over it and just rubber stamp it. But that's not the universe of supervisors. There are a lot of supervisors that, will ask you question after question after question after question. And that's part of why the district court has to have some leeway on something like this, because you want to find out what sort of supervisor it was.
But I don't render them ignorant of the results. The U.S. Supreme Court renders them incompetent to testify about that because she was not hands-on with this evidence, and that is a reframing of her testimony, that she clearly told the district court she did not redo this analysis. She wasn't involved in it.
All right.
I'll stand on my brief for the other issues.
I want to say that you're court appointed, and I want to thank you very much for your argument, and I really appreciate the vigor with which you've approached the case. But before you sit down, I never want to cut off a wonderful Judge Hyten's question. Judge Hyten?
I have no questions, thank you.
Judge Benjamin?
I have no further questions.
Okay.
Thank you, Your Honors, and I appreciate your comments.
Let us come and say hi to you and then move into the next case.
Thank you, Judge.
Mr. Cole, where's, you all come on up. We're ready to start our second case.
Thank you, Your Honors.
This is Robertson versus United States.
Good morning, Your Honors. May it please the Court. This is a relatively simple issue presented by this appeal, but I believe it's an important one. And it's whether the district court justifiably, given the Landon case, no issue there, made an error when it ruled that the government can avail itself of a state law defense while violating the intent of the state law statute. And what we're talking about here is the Virginia Workers' Compensation Act and its exclusivity for a remedy for somebody who is injured while they're on the job. The undisputed intent of that act is that all employees injured at work should have a remedy, and that remedy is going to be workers' compensation regardless of their status, whether they're an employee, whether they're an independent contractor, whether their direct employer had insurance. The basic idea is you're going to be taken care of if you're hurt at work. And sometimes the way that statute operates, the employer who ends up providing compensation benefits, it's not their employee. But there's a trade-off. There's a bargain. And the bargain is that the statutory employer is going to not be subject to third-party tort liability for that same injured employee because they could be made to provide them with workers' compensation benefits.
So, Mr. Cole, you just mentioned the word statutory employer, and I think I know the answer, but I just want to confirm.
Yes.
You are not arguing, I believe, that the DIA is not your client's statutory employer, right?
I am not.
Okay, I just want to make sure, thank you. That was just a clarification.
And the issue that's created here, and it's one that I believe the Virginia Supreme Court has tipped its hand on, but hasn't had the opportunity to opine upon, is what happens when that statutory employer cannot be made to provide workers' compensation benefits. And that's the position in which the government, through the DIA, finds itself in this situation.
But can I ask, with all, of course, respect to the Virginia Supreme Court, it's not their decision. And when it comes to a federal employer, it's not their decision, right?
I think that's, respectfully again, Your Honor, I think I disagree, and let me explain why, because I think that's the crux of the difference between the appellant's position and the government's position here. And that is, what is unquestionably true is that sovereign immunity is the province of the so-called sovereign. The government
Right,
gets
the
to
terms
decide-
under which the federal government waives its own sovereign immunity is a matter for the federal government to decide, not for the Supreme Court of Virginia to decide, right?
Absolutely.
Okay.
We can start with that. We can start with we're in complete agreement there. But the Federal Tort Claims Act has set forth the conditions under which the federal government can be sued, and the specific statute that's in play here, the one that matters, is it says that it can be sued. It can avail itself of all state law defenses. It can avail itself of the statute.
No. It says the federal government can be sued when a private employer would be suitable liability under like circumstances, right?
Understood. I'm overly paraphrasing.
So the question is not, well, again, just to be clear, the question, assuming that you could ever sue the federal government in state court, which I assume the federal government takes the view, under no circumstances can you ever sue the federal government in state court. But regardless of whether the federal government would have a defense under Virginia law to the specific action, does not matter, right? The question is whether or not they have a defense under the Federal Tort Claims Act.
But the Federal Tort Claims Act, in the provision you just cited, says the government can defend itself in the same position as a state law defendant could in like circumstances. So, for example, let's move away from the Workers' Compensation Act. Statute of limitations. The federal government in that situation would be able to well, that's a bad example. Wrong example. Let's go with contributory negligence.
So, I mean, the elephant in the room here, if we ever somehow got past the FTCA, is
Sure.
that the Commonwealth of Virginia has an extremely robust contributory negligence defense, which if you could somehow get past the FTCA bar, the government, but I think this is helpful, like the government could avail itself of the same contributory negligence defense that any defendant in Virginia can avail itself of, right?
It's the wonders of being in the mid-Atlantic with contributory negligence. But the answer is yes. And and this is where I think we might get lost in the weeds a little bit, but Virginia's law on contributory negligence would inform the same defense that the government would assert for contributory negligence or assumption of risk, and I think
It doesn't get a better contributory negligence defense than a non-employer would get.
Exactly, and that's exactly where we are with the statutory employer issue and the exclusivity clause. It is a creation of state law. The bargain that I described earlier, in which non-employers could be held liable for compensation benefits to their subcontractors, independent contractors, that is a creation of state law. Virginia, and that's why I believe what the Virginia Supreme Court would do is relevant in this case. It matters because they would determine they're the ones who would determine what happens to a private employer who could not be made under Virginia law pay workers' compensation benefits. And it's not only the federal government that's in play. Believe it or not, there is a state out there that does not require workers' compensation benefits.
Okay, but let's take the Commonwealth of Virginia.
Sure.
Isn't it the case, tell me if I'm wrong, I mean this genuinely is the question. I believe this, but I'm totally not aware of how Virginia workers' comp law works enough to be confident. An employer the size of either the federal government or the Defense Intelligence Agency, under Virginia law, there's no way they wouldn't be required to provide workers' compensation, right? Because my sense is the only employers under Virginia law who aren't required to do this are much smaller than the federal government, right?
Sure.
Okay, so an employer of similar size would not be exempt from workers' comp under Virginia law under any circumstances.
I don't think, I say this hesitantly, but I'm not sure size matters.
No, I know
That
the factual question, and then doesn't matter, but okay. But you don't have any basis to disagree with the factual proposition that an employer the size of the federal government would absolutely be required to provide workers' comp under state law.
Under state law, yes, but Virginia itself cannot
Make the federal government provide workers' compensation.
And there's statutes after statutes after
Okay,
statutes.
so why doesn't, so the reason, I guess lurking in the background is what the Supreme Court said in Olson, right? I think it's Olson? Yes, Olson. That we're not looking for a precise twin, we're deciding the sort of broader question of whether it's similar. And so one hypothesis the government, I think, advances to say, well, like would mean an employer of similar size, and an employer of similar size would absolutely be entitled to this defense under Virginia law.
Correct, but the federal government can never be in similar shoes because it is the one who decides whether it can be made to provide workers' compensation.
But so
benefits.
okay, but then thank you, because that helps key on the question of the Seventh Circuit's decision in Carter. Because you could have said the exact same thing in the Seventh Circuit's, in fact, Judge Easterbrook pointed out the same thing in Carter, which is the federal government can't be compelled to pay into this medical pool, right? And what the Seventh Circuit said in Carter is that doesn't matter under the like analysis. So in order to rule for you here, would we have to say the Seventh Circuit was wrong in Carter?
I hesitate to use the word wrong, but there are all kinds of examples where different circuits
I
have
understand.
reached different conclusions.
So that's a yes to my question?
It's not a no,
Okay.
but yes. And I think the compelling reason here, and I am not as familiar with the underlying statutory scheme in that the Seventh Circuit was ruling on, but the Virginia Workers' Compensation Act is relatively unique in terms of the breadth of people who could be liable for workers' compensation benefits. And this anomaly has been created here where there really is no remedy for somebody who, and I understand I have other hurdles to fight in this case should I get through there, but there is no remedy for the individual who's injured on the job. The government is availing itself of a statutory bar, but it's not subject to the other half of the bargain, and it can't be, which is that you're part of the pool.
I'm sort of sympathetic to your position. It seems to me that you would have, would be a good idea to have a remedy of some sort. It's difficult to be in a situation where you can't sue in tort, and you can't recover workers' compensation, neither one. And so, I mean, I'm sympathetic to that. What I struggle with and have some trouble getting around is just in following Virginia law, over the years, the one thing that stands out to me is that Virginia law is just very protective of shielding of its workers' compensation program and in shielding employers from tort suits. And I'm just not sure that we should be restricting that immunity in the absence of a signal, a clearer signal from the Virginia Supreme Court. I don't know that the Virginia Supreme Court has given a perfectly clear signal one way or another. But I guess it's the Hook case seems pretty close.
And the other one I would point to is the Gibbs case, which was relative, if I recall, was relatively more recent. It was not on all fours with the issues that are presented in this case by far, because it was an
But why would, I just don't see a clear signal from the Virginia Supreme Court or any, that would allow us to restrict the scope of the immunity that the Virginia Supreme Court has been very protective of. I mean, it's a strain running throughout the Virginia law that they feel that tort suits against employers pose a threat to the workers' compensation program, and even when you're in a situation where the employer can't be compelled to pay workers' compensation, the Virginia Supreme Court has still upheld the immunity, even when the employer can't be compelled to pay the workers' compensation. Now it seems a very difficult situation for your client to be in, not to get workers' compensation and not to get the opportunity to sue in tort, but I just, my whole question is whether we really have the basis in Virginia law to restrict the immunity that the Virginia Supreme Court has accorded employers. That's the difficulty that I have.
And Your Honor, I understand I'm getting very short on time, so I will try to be brief, but I do want to briefly respond to that point. First of all, that's part of the reason why we requested certification to the Supreme Court, both at the district court level and when we filed in this court. I believe that this is something that, at its best, this is a matter for the Virginia Supreme Court to weigh in on.
Have you identified literally any case where this court has ever held that a district court abused its discretion by not certifying a question of state law?
That might be the biggest hill I've ever tried to climb in my legal career.
It's a big swing.
It's a big swim, and if I would be, all I can say is I am unaware of any authority to suggest that, so I am not focusing on that for the purposes of my argument today. I am out of time. I have reserves for rebuttal.
Good morning, and may it please the court. Elizabeth Spavins, Assistant United States Attorney for Defendant Appellee, the United States. The district court should be affirmed. The district court properly dismissed plaintiff's claims under the Federal Tort Claims Act for lack of subject matter jurisdiction because the Virginia Workers' Compensation Act would preclude plaintiff from bringing tort claims against a private party under, quote, like circumstances. Specifically, the Federal Tort Claims Act state law analog, 28 U.S. state law analog provision, 28 U.S.C. 2674, only authorizes the United States to be liable in the same manner and to the same extent as a private individual under, quote, like circumstances. Thus, the United States is only liable for plaintiff's tort claims to the extent a private party would be liable under Virginia law in like circumstances. as this court has said in Kearns, among other cases. Here, the relevant state law analog, the Virginia Workers' Compensation Act, specifically under the exclusivity provision of that act, states that the rights and remedies provided exclude all other rights and remedies of a covered employee for injuries sustained in the course of employment. As noted in our brief, and also again here today, the plaintiff is not disputing that the DIA is her statutory employer for purposes of this case. Accordingly, the United States may only be held liable in the same manner as a private individual under like circumstances. The plaintiff could not bring a cause of action arising out of any injuries in the workplace in Virginia, and therefore the United States has no liability under like circumstances, and thus the district court ruled there was no jurisdiction under the
can I ask you,
FTCA.
the cases, I was a little surprised, honestly. The cases, none of them seem super on point to this one. I'm not saying that we have to decide the case in front of us, but have you as a factual matter identified any case where a court sort of did the like circumstances analysis and the conclusion is the plaintiff can't sue anyone for anything at all? Because none of the cases cited in the brief seem to involve that fact. Like, so the Seventh Circuit decision, you say, we're going to cap the amount of recovery you can get. Or other cases say, you can't sue the federal government, you can sue somebody else. But this woman seems to be in this sort of position where the logical conclusion of your argument is the number of permissible defendants is 0, and the amount of permissible recovery is 0.
Well, I would point this court to a couple of cases. I would point the court, understanding it is on, well, first let me point the court to Evans v. Hook, which
Sorry, other than our unpublished opinion.
No, sure. In Landon, putting aside Landon,
Right.
that's unpublished.
Sorry.
Vernon is also unpublished. Vernon is the South Carolina statute, but it is actually, I think, quite illustrative because the South Carolina statute is similar, and in addition, the South Carolina statute actually says, you know, the state law specifies a carve out for the United States, and this court said, well, it doesn't matter. We're looking at like circumstances. So I think the analysis is informed by those cases. As far as...
I mean, Landon is the one that basically is this case or very close to this case.
The only distinction in Landon that plaintiff asserts is that because of the plaintiff in Landon's employment structure, that person could go after another person in the chain. Right. The difference here is that plaintiff was the sole proprietor, so she doesn't have an independent contractor.
And I mean, also, again, you've got Landon literally gives no reasons. It just says you can't sue them. Like, there's no. I mean, it's not just that Landon's not binding in a formal sense. It's almost like Skidmore deference. Unpublished opinions are as persuasive as their power to persuade, except that opinion gives literally no explanation. It just asserts that's the answer.
The Landon analysis is limited, but I wouldn't say it's 0. I mean, the decision in Landon does explicitly note that Gibbs notwithstanding, it can make this decision. Certainly, it could have elaborated for all the reasons that Gibbs is not on all fours, but plaintiff herself acknowledges Gibbs is not controlling here, both because, for a variety of reasons, which I'm happy to get into. I agree the analysis in Landon is limited, but I wouldn't say it's 0, and the reason is it tracks the many cases that talk about how even if the federal government is not part of a state remedial scheme, nevertheless, under the FTCA, the like circumstances analysis.
Yeah, this is the part where Carter is basically on all fours, right? Because Carter considers this exact argument and rejects that exact argument.
Yes, that's right. And in addition, I would, to the extent this court wants to also look at its own decisions, the Starnes case, which is about a different Virginia law, but it's very similar in that it's a comprehensive state scheme, the Virginia medical malpractice cap, and this court in Starnes holds that even though a federal government medical facility isn't regulated by the state of Virginia, which is part of the Virginia law, nevertheless, we are including, under the like circumstances analysis, we are looking to that law to determine if this statutory cap applies. So absolutely, it's different to say, well, we're applying a cap like in Starnes or in Carter versus no liability at all. But the analysis is always the same. It's looking to the state law, even though the federal government is different than a private party in a liability sense or in a regulated sense. So I think that's the proper lens with which to analyze. And the reason is, I think, as Judge Wilkinson pointed to in Evans v. Hook, which is the Supreme Court of Virginia, specifically said, Even though an independent contractor may not have been liable for payment of workers' compensation benefits to the injured employee, he is still entitled to such immunity. Now, in that instance, it was an architect who was a solo, and as Your Honor noted, that is a small carve-out under the comprehensive Virginia workers' compensation scheme, that if you have very few employees, you don't.
Right, so one way to think about this is any remotely comparable employer in Virginia would 100% be paying into workers' comp.
Precisely, and that's the inquiry. The inquiry isn't working backwards, well, if someone is left out of no workers' compensation and no tort claim, therefore we must find jurisdiction in a federal court. That is not the way that analysis works. To the contrary, we start with,
But what is this person to do? You know, he can't sue in tort, and he can't recover workers' compensation. And so what does he do if he's been negligently injured?
so if we're asking about this specific individual, of course, the government did move for summary judgment on the basis of contributory negligence, as Judge Heitens noted. So this person may be left out in the cold as far as damages anyway because of a different Virginia statute, just to address this individual's factual claim. But nevertheless, it is our position that if the analysis goes that under the Federal Tort Claims Act, the state law analog provision means that the person does not have tort
Is
claim.
the bottom line position, are we stuck with the thought that, well, they're violations of law for which there is no remedy?
Well, I would say,
For which there's no clear remedy. Are we just stuck with that proposition that, you know, that not every legal infraction has a remedy? I'm sure that's true in a number of cases. Is that where we're left?
yes, you're under the Federal Tort Claims Act, there are only some waivers of sovereign immunity. And so it is the case that
And that's
this,
what the cases are. A number of our federal appendix cases and seem to indicate it's probably legally correct, but it's not very satisfying, I must say.
Your Honor, I guess I think it is correct. And as far as the satisfying element, I would say that the law is clear that the district court is of limited jurisdiction. It has to look to the waivers of sovereign immunity. Those have to be expressly construed.
I mean, because the baseline of sovereign immunity, it's difficult to say, right? But the baseline immunity is that if the federal government does something bad to you, you have no remedy unless the federal government chooses to give you one, right? That is the sort of legal baseline. And then this statute says sometimes we'll give you a remedy, but I guess implicit in saying sometimes we'll give you a remedy is saying sometimes we won't.
Yes, Your Honor. The waivers of sovereign immunity, the sovereign can only be sued when there are waivers of sovereign immunity.
So, you've got two sets of immunities here. You've got the immunity that the federal government has inherently, and the fact that we are being cautioned repeatedly not to expand or imply the federal government's waiver of sovereign immunity. And then you've got the Virginia Supreme Court, which has another immunity which we are not supposed to restrict. So you've got one immunity which we are told we're not to expand the waivers of that immunity, and then we got another immunity which we are told by the Virginia Supreme Court we're not to restrict. And so this is sort of in between the two immunities, and I understand all the legal obstacles to the appellant's position. They're formidable, and I have no desire to start implying waivers of sovereign immunity or restricting Virginia immunities. All I'm saying is, I think your position is very sound as a matter of law, as a matter of facts. As a matter of fact, I find it unsatisfying that this person could have been in a car accident with a negligent driver and nothing happens. So is there some way you can make me feel better about it?
Yes, Your Honor. On these facts, the government did move for summary judgment on the basis of that in this incident, which only involved one driver, which was the plaintiff, there was contributory negligence. Plaintiff drove against a red light, against an arrow pointing in the right direction, up onto a barrier. So she was driving on the incorrect side of the road to go out an inbound lane. That's the incident that's at issue here.
I'm guessing you would probably say if it was a two-car accident, that the remedy that this Ms. Robinson, I think is her name, would probably be the other car's insurance. Right?
That's exactly right, yes. Or, of course, an individual who is a sole proprietor could have their own insurance to cover workplace incidents themselves. None of that is none of that is expanding the government's liability here. But in this situation, this person is without remedy because of the unique circumstances of their case. But again, even in a substantive, on the merits, the government's position is there is no remedy here because of Virginia law and contributory negligence. So it's not a situation where the layers of immunity that Judge Wilkinson described are preventing, are the only thing preventing someone's recovery. There are other substantive issues at the merits as well. And as Judge Benjamin points out, there could be other circumstances where there would be another person that the person could pursue damages from, whether an independent contractor or another, if there was another individual
Well,
involved.
Thank you very much. And hold on a minute. I'm going to ask my friends on the panel if they have any further questions. Judge, are you okay?
I do not.
All right, we thank you.
Thank you.
You have some rebuttal time, sir.
Thank you, Your Honors. I want to respond briefly to the government's characterization of the underlying accident. There was a DVD footage from security camera on the scene. It's a little more complex than that. The exit to the facility has two barriers, two lanes. The security guard put the barrier down to one lane and instructed her to go out that lane. And then when she was going out that lane, blew the barrier up underneath it. Contributory negligence is almost always an issue for the finder of fact. It is rarely a dispositive on summary judgment, and the court below did not decide.
I mean,
this
under
case.
Virginia practice, you basically can't get summary judgment, right?
In state court, yes.
But here you'd be in federal court.
But we're not there. But as far as the substantive case law, it's usually a fact issue, and it's where reasonable minds could disagree. And the district court did not grant the government's motion for summary judgment. It didn't rule on it, and that's not why we're here today. We're here on the grounds the district court did rule on, and that is the sovereign immunity issue. And to respond to Judge Wilkinson's comments, I don't think we're asking to expand the waiver of the sovereign immunity under the Federal Tort Claims Act. The question that's presented here is
Let's test that proposition.
Sure.
What is the most analogous case to this one that you've been able to identify where a court found a waiver of sovereign immunity?
It's a tough call because I haven't really found one. But I do not believe.
So that sounds like an expansion then.
We're not, I would humbly submit that we're not dealing with increasing or growing the waivers of sovereign immunity. We're focusing on what I'm focusing on, and I believe where this appeal turns, is what is the scope of the defense under state law that the federal government is utilizing? Much like if it's utilizing contributory negligence as a defense in the case. What is going on under state law that the government is using as the defense? And in this case, except for smoke signals in cases like Gibbs, it's unclear.
You mean like footnote 2 where Gibbs says we're literally not purporting to opine on what the rule under the Federal Tort Claims Act would be?
Correct. But I think in the Gibbs case, again, not on all fours. I have never suggested it's controlling. But in the Gibbs case, it did hold that the Navy was not the statutory employer.
But not in the course of deciding whether you could sue the Navy, in the course of deciding whether you could sue someone who wasn't the Navy.
Sure, and that's the issue here. There is no one else to sue. To use the car accident example that Judge Benjamin mentioned a second ago, suppose it was a two-car accident with a federal employee acting within the scope. You couldn't sue, there would be no remedy in that situation either. Let's hypothetically say that this was an accident in the parking lot at the DIA with a DIA security guard. My client would not have been able to sue anybody in that situation either, or recover workers' compensation benefits.
Why do you say that they wouldn't be able to sue them? Because it wouldn't be, of course, the workers' comp exclusivity wouldn't,
Okay.
would not, even if the Virginia workers' comp exclusivity wouldn't apply, I would assume that they're under traditional tort insurance laws that they would be able to sue.
Not if the tortfeasor is a federal employee acting within the scope. DIA employed security guard hits my client in the parking lot, which does trigger the workers' compensation exclusivity. She couldn't bring a tort suit against the DIA employee who hit her.
Because just to walk through the reason, because the government would substitute itself as the employee and then move to dismiss based on sovereign immunity?
Because you can't sue a federal employee when they're acting within the scope.
But if you purported to do that, what would happen is you'd say, you can't do that, the only possible defendant would be the federal government itself, and then the federal government would say, we have sovereign immunity.
And we're right here with the same argument. So I don't think I think it's broad. I think the issue is broader than just my client in this particular case. I think I will submit on the brief at this point. Am I the first person ever not to use all of my rebuttal time?
Thank you, sir.
Thank you.
All right. Appreciate your argument. We'll come down and shake hands, and we'll proceed into our final case. Is that okay?
Absolutely.
All right. We'll come down and say hi to you.
It is the first time I've actually had a hearing. So thank you for being here. Thank you. Thank you, Robert.
Thank you so much. Thank you so much.
Mr. Shepherd?
Yes, sir. Good morning, Your Honors. May it please the Court. My name is Ray Shepherd. I'm here on behalf of my client, Brooke Summers. In the appellee's brief, Officer Devine tells us that he arrested my client because of the volume of her speech. That's on page 21 of.
Doesn't he testify that he arrested your client because he ordered her to leave and she wouldn't?
Yes, but in the brief on appeal, he argues that he arrested her because of the volume of her speech. That's on page 21 of the appellee's brief. The district court, of course, dismissed these counts on the basis of qualified immunity. So we have to look to see what was well-established law at the time that the officer made the arrest based on the facts that were presented to him. And we'll get into the alternate testimony as well. But let's go with what he's arguing on appeal, is that he arrested Ms. Summers because the volume of her speech was too loud. That implicates the state Supreme Court's case in Eanes, which held that if you, and there's a number of decisions where the Supreme Court, both of the federal Supreme Court and also the Supreme Court of Maryland, used to be the Court of Appeals, has dealt with the overlap between the First Amendment and state criminal laws. So,
You're talking about the First Amendment here.
yes,
We're having, this situation is replicating itself across the country where people are attempting to disrupt school board meetings. And the question, I think that there are people who wish to bring legitimate interests and raise legitimate protests to what school boards are doing. And their parents are obviously very sensitive about what their children are reading and about mask policies and everything. So school boards are really in a tough kind of situation, but the folks who are protesting also have points that they want to make. And so the question I find, one of the questions I ask myself is, are the police officers who are charged with drawing the line between protecting expression and also keeping order, was there any expression that, it seemed to me that the officers' actions were content neutral as opposed with regard to the individual here. I don't see in the record what would concern me the most, which is that the officer was taking action based on disapproval of the protesters' message. And I did not see in the record that he made any statements that were other than content neutral, which is you've got to quiet down with the meetings going on or whatever, but he didn't indicate that he agreed or disagreed one way or another about the mask policy or whatever. But wasn't this a content neutral action on the part of the officer?
well, I'm going to answer in two respects, Your Honor. First, the court's question presumes that my client was a protester.
Was what?
A protester. She was there, 40 minutes went by where she's sitting outside. She was not disrupting. I mean, there's no evidence other than the officer's testimony that there was a disruption.
You say
But let's assume that there was.
There was evidence that the school board members were looking back or looking toward the door and
That's a disputed, those are disputed facts, Your Honor.
well,
But-
of course, any incident is always disputed, but I mean, I'm talking for purposes of
Right.
qualified immunity.
Let me get directly to your question.
I
You
just
asked,
don't see that the officer headed in for the protesters' point of view.
I would respectfully disagree, Your Honor. Here, the facts are, my client's sitting outside, having a conversation with other people. The officer leaves the room, and this is, you don't take my word for it, there's video evidence, this is all recorded. He leaves the meeting room and says to the group, "Keep it down." My client responds in a normal tone and voice and says, "No." The officer, immediately upon hearing the word "no," points to the door, starts walking towards my client and says, "Get out, leave now, or you're going to be arrested."
Okay, so,
And-
thank you. You just brought up what I think is the critical part of what I'll call part one of this instance.
Yes.
When an officer directs you to leave or to do something and you say no, well, why isn't he entitled to direct you to leave at that point?
Because the Supreme Court has made it extremely clear that a citizen has the right to protest peacefully
Sure.
an officer's instruction, even a lawful instruction.
They
And-
have a right, well, sorry, they have a right, they absolutely don't have to agree 100%. You don't have to say you agree with everything a police
That's right.
officer says. You don't have to agree. You can protest it, but what you can't do is when faced with a content-neutral statement, I need you to keep it down, right? The statement was not, stop protesting or I don't like your sign, but when they say, I need you to keep the volume down, which is pretty much the definition of a content-neutral time, place, and manner restriction, saying keep your voice down is content-neutral, time, place, and manner, and you say no, as in, I do not intend to keep my voice down.
I'm not sure that's what it meant.
Really? Because I've watched the video, and it seems pretty clear that it's what it means to me.
Well, the circuit court judge said on the record that he wasn't sure what no meant.
Okay.
But
Well, it was
let's
in
assume.
response. It was in response to him saying.
I understand. Let's assume-
It was in response to him saying, "I need you to keep it down," and he wasn't just speaking to her. He was speaking to the group that was sitting
That's
out
right.
there. And you said in a normal voice, but I'm not great at estimating, but she wasn't right in front of him. She yelled out no.
She didn't yell out no. She said
Well,
no.
you would agree that they were not face to face, probably not as close as you
Oh, they
and I.
much farther away than us.
She said it loud enough where he could hear it. So his question was whether that was in her normal voice.
I don't think even Officer Devine or counsel today will say that she yelled it. And that's on the video. I mean, it's in a normal tone of voice. It's less loud than I'm speaking now.
But it
the-
was
but-
asked to, it was asked to, in response to his statement to hold it down.
Yes.
Okay.
Let's assume that we take the leap that the court is taking and that what she intended by that statement is, no, I'm not going to keep my voice down. Let's assume that's what she meant. I don't think that's demonstrated by the record, but let's assume that it is. What the Eanes case said is that before you get probable cause to arrest based on the volume of speech, you have to have a warning, which I don't have a problem with what he did in terms of a
Keep
warning.
your voice down is kind of the definition of a warning.
Absolutely. And I'm not arguing that there was anything improper about that. But what I'm saying is, before the officer gets to probable cause, under the Eanes decision, there has to be not just a statement no, but something that violates the volume that is too loud. After you have to actually disobey the order. She never disobeyed the order.
The statement is, I
Right.
intend to disobey any order in the future.
I don't believe that's what she meant.
But the question is what a reasonable, certainly,
Right.
gosh,
Look-
by the time we get to qualified immunity, the
Right.
question is not what she meant. The question is what an objectively reasonable
Of course.
officer could have thought she meant.
Well, let's assume that that's the case, and the officer assumed that she intends to not keep her voice down. The question then becomes, does he have the right, at that moment, does he have probable cause to arrest her or
No,
to
what he has
order
the
her
right
to
of-
leave the building?
What he has the right to do at that moment is to say, leave the building. And if it's a lawful order to leave the building, and she disregards the lawful order to leave the building, then he can arrest her because now she's in a place that she's not allowed to be and she's refused to leave.
But, Your Honor, respectfully, the order to get out of the building, without a violation, you can say, I could say I intend to murder my neighbor.
Uh-huh.
But I don't actually murder my neighbor. It's just, you're not going to arrest me for murder, right? Because
No,
right.
That analogy doesn't work at all. I guess what I'll say is,
Okay.
if Judge Wilkinson were to say, let's say you were to inadvertently violate some rule of how you're supposed to behave in this room at this time, and Judge Wilkinson were to say, you violated the rules, don't violate it again, and you said no, I assure you that what we would do is we would call someone in here and say, if you've just said you're not going to follow the rules,
Yeah.
we would ask the person sitting at the desk to escort you out of this room.
Okay.
And then if you refuse to leave the room, we would escalate the situation one step further, and you would be escorted out of this room, whether you wanted to be or not. I guess I just don't see how that's different from this situation. At least, or
Well-
how, if an objectively reasonable officer could have interpreted her no as a statement, I don't intend to keep my voice down, I don't see why everything that happens after that is not constitutionally permissible.
Well, the answer is Eanes versus State, where the Supreme Court of Maryland said that he admits he's arresting on the basis of volume. And can an officer arrest you on the basis of the volume of your voice because he thinks?
She wasn't arrested for the volume. She
That's
was
what he
arrested
says.
Because she disregarded the order to leave.
That's not what he says.
It ultimately, for Fourth
But
Amendment
you-
purposes.
you-
Okay.
You have a patient officer, he didn't just ask her to leave one time, he
That's
asked her to
right.
leave 4 times, at least multiple times. We might disagree whether it was 3 or 4, but the officer showed some patience here. And as I say, one of the things that concerns me is that school boards are really under fire these days. And if we reversed, we would be putting our imprimatur on disruptive behavior in school board meetings. And there's a good bit of that already. But it's gonna get to the point where people are not gonna wanna serve on these boards if it becomes too disagreeable. And what you have here is you have a patient officer, content neutral, making repeated requests. Repeated requests were rebuffed. And finally, he was forced to the point of taking action. And he's trying to draw a line, as far as I read the record, between allowing protests and avoiding disruption. And that's a tough line to draw in these kinds of situations. And as Judge Herson indicated below, it's the very kind of judgment call for which qualified immunity was intended. And I think the implications of a reversal would be pretty unfortunate for the orderly conduct of school board meetings.
Accepted. Let's move on to the use of unreasonable force, because that I don't think has anything to do with the school board or issues like that.
Well, I guess the problem you have is if the probable cause is established, if the officer had probable cause and on the excessive force, you're gonna have an issue on Graham, step 3, prong 3.
No, step 3 on Graham is just whether the person's resisting. I mean, you can have.
But she acknowledged that she was resisting. That's gonna be the problem you have with qualified immunity.
Well, may I, there's 2 instances of excessive force, one at the courthouse, one during the arrest. Let's go to the courthouse one for a second. She's under the 14th Amendment, and as was alleged in the complaint, she was not required to wear a mask in the courthouse. There was other people in the courthouse without a mask. The court viewed a videotape that is not conclusive and said that the officer acted reasonably in requiring her to wear a mask and throwing her to the floor. Now, the court says she sat down on the floor. I hope you've looked at the video. That's not the case.
All right. Thank you,
Okay.
counsel. Let me just see if my colleagues have some questions.
No, thank you.
Judge Hyten? No, we don't. Mr. Mueller?
Yes, thank you. May it please the court, the district court's judgment should be affirmed, for 3 reasons. First, Officer Devine had probable cause or reasonable belief that he had probable cause to arrest Ms. Summers. Second, the force he used was objectively reasonable. He did not throw her.
Does it make any difference that the convictions were later reversed
It
on appeal? Oh.
I'm sorry, it does not.
Does the fact that the convictions were later reversed make a difference?
It does not. Under assumption, a reverse conviction does.
Your view is that the convictions itself
Are
brought it
presumptive.
within the range of objectively reasonable behavior.
Correct. The convictions are presumptive of probable
Right.
cause, even with the reversal on appeal, unless there's fraud or perjury.
Let
And
me
here,
preface this by saying I have no idea if this actually affects the outcome in this case for a variety of other reasons, but that's a weird rule, A. And B, a federal court isn't bound by, unless you can explain to me why we would be, a federal court isn't bound by the terms of a state law defense under 1983, are we?
No, but no.
So, like,
I
I
don't
mean,
think-
Maryland can decide for themselves that the fact that the court of first instance found probable cause means there's probable cause as a matter of law, irrespective of what a circuit court later says. But that's not binding in federal litigation, is it?
Well, I don't think it should be disturbed because it's the court of first impression that is making determination that there is indeed probable cause for the arrest, not necessarily beyond a reasonable doubt, but there's
I
probable
guess
cause.
what I guess I'm just saying is my sense from the briefs is that Maryland state tort law says if it's the court, is it the general district court in Maryland? I can't.
No, that was, the initial conviction was in the district court. It was appealed to the
Sure, okay.
Maryland
so
Circuit
as I
Court, yeah.
so let me say, my understanding is for Maryland tort law purposes, the district court's initial conclusion that there's probable cause is preclusive as to that issue in any future litigation, irrespective of what happens in the circuit court. Is that a correct statement?
That is correct.
Okay. But there's a separate question about whether that rule applies in federal court in litigation brought under Section 1983. And I don't see why it would, because the rules in federal court under Section 1983 are not determined by the contours of Maryland tort law. They're determined by the sort of federal rules of Section 1983, right?
Right, let me correct one thing I said. It's presumptively.
Presumptively,
Yeah,
but all of that stuff.
Right, yeah, I just wanted to clarify that. But there is, it's Heck v. Humphrey, which is a Supreme Court case, which the court considered what are the parameters for being able to bring a 1983
Well,
claim.
perhaps the answer is it's a federal question, but the federal question could be informed by what happened in state court. It's not, the state court, I think my colleague is exactly right. The state court can't be preclusive of the federal question and the probable cause, but it is just it's part of the body of evidence that could inform a conclusion of probable cause under 1983.
But Heck,
It's a piece of evidence rather than a legal conclusion, I suppose.
okay, I do believe, though, Heck v. Humphrey says a 1983 claim requires that the underlying criminal conviction that you're challenging be set aside in some manner.
Yes, but,
Yeah.
but Heck versus Humphrey says that as a matter of federal law.
Right, yes, okay. I don't mean to quibble on that, I'm sorry. So the second reason was that his use of force was objectionably reasonable. He didn't throw her to the ground. The video's pretty clear that she went to the ground on her own. And even if he had...
Because your colleague on the other side said there are arguably two instances of a seizure for the Fourth Amendment. There's what happens at the school board meeting, and then there's what happens at the courthouse. And when you say he didn't throw her to the ground, you mean he didn't throw her to the ground at the court? I'm just trying to make sure what part of the incident.
I don't think he threw her to the ground either time.
Okay,
To me, throwing conveys some sort of real force to the ground. He may have taken her to the ground, but that's not unconstitutional. He had a probable cause for arrest. She resisted arrest by refusing to stand up, and he took her to the ground. If he took her to the ground, he could take her to the ground. It was legal.
If she took herself to the ground, he could stand her back up, right? Like,
If he could have, but at that point...
right, that I'm saying.
Yes, he could, right, correct. And they eventually did stand her back up at the school board meeting after they had to cuff her, handcuff her. And then, so I guess really just two reasons. So in this case, the probable cause was evident from her actions at the school board meeting first, where she arrived without a mask. She presented an 8-month-old note indicating that she said she couldn't wear a mask. She challenged the enforcement of the policy as so dangerous, asked if he wore a mask at home, told him what every mask protester has used, it's a mandate, not a law. And she admitted that it was, she wore a mask when it was logical to do so. And so her behavior put him on notice that she was there to disrupt. Okay? She's not being arrested for those reasons because, as opposing counsel said, 40 minutes went by before he approached her again. And he only approached her after the noise after the noise from the lobby disturbed the meeting. And we know that because Officer Devine testified to it, Mr. Roush from the school board testified to it, and the video shows that several members of the panel in the back of the room to Officer Devine's left looked at him several times, and showing that they were obviously disturbed, and that was his.
This is one of those cases where it's a little bit treacherous to apply too much 20/20 hindsight. The officer was confronted with a situation that was unfolding rapidly in real time, and we can chew the bone months afterwards, but the officer had to make a judgment call in a matter of minutes, and it's really a difficult task. I don't envy officers because they're required to protect protest on the one hand, and then they're required to maintain order, and they're required to sort of strike a balance between those two under very difficult circumstances. And but you know, we can ruminate, but the very time devoted to oral argument in an appellate court probably in most cases exceeds by many multiples the time that the officer had to make a decision. We'll spend an hour, 40 minutes talking about this, but most officers don't have that kind of time. And so it seems to me what the Supreme Court is saying, you know, somebody really runs off the rails, courts have absolutely got to draw that person to account. But this officer didn't run off the rails. He was a patient person. He was just going about trying to do his job.
Well, I agree, and that's what you quoted Judge Hurston, and he said, hey, this is the very type of case qualified immunity exists for. We have an officer who has demonstrated his patience repeatedly. He was patient when she first arrived. The testimony is that the noise grew out in the lobby, but they waited with the hope that the folks in the lobby would quiet down. There's no discussion of any of the content. They couldn't make out the content. They heard laughing and loud voices. And so after 40 minutes, it was roughly 40 minutes into the meeting, that after a few looks from the school board, that's when Officer Devine goes out and confronts the crowd. It doesn't say, hey, stop talking about whatever you're talking about. He says simply, quiet down. So he was extraordinarily patient. He tells her to quiet down. She says no. He gives her 4 or 5 orders to leave the lobby before he placed her under arrest. So this is exactly the type. He's trying to maintain order in the lobby because it's disrupting the school board behind closed doors.
I understand that. I think you both written good briefs here, and it might be most productive at this point to ask my colleagues if they have particular questions for you.
I do have one, actually. Judge Benjamin, though.
I don't have any.
So, does it matter, I guess what I'm trying to figure out doctrinally, does it matter if there was in fact being excessive noise? Like, your friend on the other side basically says, like, as a factual matter, there wasn't excessive noise. And it's not clear you could hear it in the room. But then the question I guess I had is whether that matters at all. Because it seems to me that the officer probably could have said, like, whether or not they were in fact being too loud. It does, in fact, seem like the officer can say, everyone needs to keep their voice down. I don't see anything unlawful about the officer saying, this is a public meeting, I need everyone to keep their voice down. Like, I don't think we do it here, but like in the Supreme Court of the United States, the marshal says, silence is commanded while the court is in session, right? There's nothing wrong with saying everyone needs to be quiet in certain settings, regardless of whether they've been loud before, right?
Right.
And once she says no, and once the officer reasonably interprets that as, I do not intend to be quiet, he can order her to leave. So I guess, could you just elaborate on what, if anything, do you view the significance of whether there was in fact excessive noise at the time the officer had ordered her to keep her voice down?
I think the significance is whether or not Officer Devine interpreted the noise reasonably as excessive. And what happened while he was there, he was the one that received the looks from the panel, which told him, hey, I'm disturbed by what's going on there. And he had looks from several members of the panel. He interpreted the noise he heard combined with the looks from the panel to say, the noise is disrupting this meeting for me.
Let me try it in a different way. Imagine that that's all totally wrong. Would it matter?
I think as long as under qualified immunity, I'm not sure if I'm answering your question, I apologize, but I think
No, but your friend
under
says-
qualified immunity,
So you're-
if he reasonably believed the noise was too loud, that's all that matters. So, I'm sorry,
You okay,
Yes, I am.
Judge?
Yes.
we simply ask
Thank
that you
you.
affirm the ruling of this.
Thank you, sir.
Thank you.
Mr. Shepherd?
Thank you, Judge. I want to go to the courthouse use of force. I understand where the court, I try to listen during these arguments so I can tell what the judges are thinking. And I hear you loud and clear. But at the courthouse, she was not required to wear a mask, period.
The court took judicial notice of the fact that unvaccinated people were required to wear a mask in that courthouse. True or false?
Yes, but there was no evidence in the record as to whether she was vaccinated or not. We made the representation. I thought that the court was required to take all facts alleged in the complaint as true for purposes of summary judgment.
Well, no, that's not true. You don't
Well-
have to take all facts alleged in the complaint as true. You have to at 12b6, but you don't at summary judgment. At summary judgment, the party opposing summary judgment has to produce evidence that would allow a fact finder to find something.
Right, but there was no evidentiary hearing. But my point is, we alleged.
Did you submit a declaration saying that your client was vaccinated?
No.
So then, based on the record before the district court, your client was required to wear a mask inside the courthouse, absent evidence from you that she met the criteria for not wearing a mask inside the courthouse.
Okay. I hear you. So let's assume that she was. I don't know. But I don't think you can get there, I thought you draw reasonable inferences from the facts in the light most favorable to my client.
Absolutely.
I don't believe that happened in this case, Judge. But I guess what you're saying is, I mean, my opponent says, well, and the court says she sat down. The video doesn't show that, okay? Why did he put her on? And then you asked the question about at the arrest, well, is she allowed to get up? Well, she asked that question at the courthouse. Can I get up? The officer said no. Made her stay on the floor for 7 minutes. How is that? I don't think that's, I think that's a jury question. I don't see how, I understand all of you may think that that was totally reasonable. I'm not going to debate that. I'm not here to debate that. What I'm simply trying to say is it wasn't so clear cut that it should have been decided as a matter of law.
But that's the point. It is rather clear cut.
What-
What is clear cut is whether it was objectively reasonable. Not, it doesn't, you can say, was the officer right or wrong? Or should he have done this, should he have done that? But there can be disputes, but the question ultimately, was it objectively within the realm of reason? And if it was, the Supreme Court says the immunity should be applied earlier in the litigation rather than later, because in these sorts of situations, if you go before a jury and have to litigate it through, the value of the immunity has already been lost. And you just come back to what the officer did. In its totality, was it objectively reasonable? And to hold that there was a question about this, as I mentioned on a global level, these school boards are under fire And they make very questionable decisions, in my view, that upset a lot of parents. And I'm sympathetic to parents that really get upset with school boards and what they're doing. But the school boards have a right to do, they're elected officials or appointed officials. They have a right to discharge their duties with just a modicum of order and peace. And that's what's at stake in a case like this.
Well, not at the courthouse, Judge, but if you're, respectfully, I'd like to get back to one point. I know I already get the sense you guys are going to rule against me, but I want to make one point before I leave the podium, if I may. Going back to the arrest and the order to leave the building, the only basis was the word no. In my humble opinion, that runs to say that the officer had the right to tell her to leave the building based on the word no, even if she meant, I may raise my voice in the future. I think that's a problem to say that that's a lawful order to leave the building, Judge Heitens, under Eames versus State.
You can't read this record without thinking this individual came to that meeting determined by whatever means to do away with this mask policy.
I couldn't disagree.
And if it created an incident, so much the better, because an incident would generate publicity and it would magnify the message, and so the thought crossed my mind that this individual arrived at the meeting with the idea of creating an incident in mind. And, that's not good. You can want to create the incident, but there are consequences that come with creating the incident. And one of those is that you have to leave to allow the school board to discharge its democratic responsibilities in an atmosphere of some order and peace, and take a sign and protest the mask policy, write a letter to the editor, ask to appear before the school board, ask for a few minutes to talk about the mask policy, write the school board members, see if you can request a chance to talk with them, work against their reelection. All of these things in a democratic society one can do. But what one cannot do is what she did. That's just speaking for myself.
Understood, Judge. May I make one last comment and I'll sit down? I know I'm out of time.
I'd like to know, what was the thing that you attempted to say you disagreed with something? I'd like to
Well, I disagree with the premise of the findings that the court is making with respect to my client's intentions, and that I don't see this case in that light at all. But I understand what Judge Wilkinson is saying, that the school board has a right to conduct business just like this court does. And I totally understand the desire for order. No objection to that. The United States Supreme Court in Hill said that the right of a citizen to protest or disagree with a police officer peacefully and not risk arrest or punishment thereby is the difference between a free nation and a police state. Her saying no, regardless of what you guys are saying, is that because she said no, and a reasonable officer could interpret that as she might get loud again, assuming that she was, which is not conceded, that gives him probable cause to say you can leave. I'm saying that's incorrect as a matter of law.
Police states don't request peaceable actions 4 different times. They come and drag people off without any explanation. They don't make the request that this officer did. You
The-
can
the-
tell-
the-
you
yeah.
can tell me you think that everything I've said has been wrong, and
I'm not going to do that, Judge. I
and-
respect you too much.
And I always tell litigants how much I appreciate their passion about their case. And I say, if you're mad with me, you don't even have to shake hands with me.
Oh, I would never do that. I would never act that way, Your Honor. Thank you.
Okay, we thank you. Appreciate your arguments, and we will adjourn court and come down and re-counsel.
This honorable court stands adjourned, sign and die. God save the United States and this honorable court.